okay, so what's the concern? Did they say some stuff that was helpful that's in the draft phase of things that's now not making its way into the written IEP document that's the final document? That problem could be managed nicely with an audio recording, although that's rather inefficient. The district doesn't have an obligation to give you draft IEP document necessarily. They could do everything orally, but when they come in, don't they hand you a draft document? If they don't, they're doing that sneaky thing of they're reading from their draft and you're like twiddling your fingers because you don't know what they're looking at. You need to explain to them that you need a copy of whatever they're looking at, and if the tape if the audio is recording, it's hard to imagine that they're going to give you pushback on that. Yeah, different. LAUSD does it exactly backwards of that. LAUSD sends you home with a draft IEP that's not a final document, so that's not legal. So actually, I think what's happening is this district is actually doing things the right way, which is that they're sending you home with a final document that's a final offer that you can rely on, as distinct from like the LAUSD situation where if you have an IEP and it says draft splashed all over the front, that's, you know, one nice issue in your due process hearing request when you get there, which is district never made a final specific written offer of placement. So,
but this idea of it being locked, Bonnie, I think sometimes that suggests to us as parents, they've given us a locked document. So if we go, oh, I disagree with this, then there's nothing to be done. So when they say locked, it doesn't mean that.
That I think folds nicely into another question which we had on the same day, which is when I get my IEP document back, may I add some kind of addendum to it, or am I limited to the little tiny 1-inch, square box on page 19 of the document? So the way you deal with a locked IEP, or for that matter, any IEP that you want to comment on, is you do what we call an IEP response. And if people really wanted to see what one looked like, we could redact one. But we basically go through the document, and where the parent's signature is on the IEP itself, we write, please, big asterisk, please see attached letter of blah, blah, blah date. And then we begin writing a letter. Dear IEP team, student consents to eligibility under autism. However, student thinks district was wrong in not, offering a second eligibility category of specific learning disability. Student consents, student believes that the present levels of performance as reported at the IEP team meeting were inaccurate with respect to executive functioning. With respect to goals and objectives, the district failed to write a goal in the area of attention. We think this was an oversight. As to the services, we think the services are appropriate, but the district should have added an additional 30 minutes a week of individual speech therapy. And then we usually sign off by saying, we consent to implementation of the IEP, but we don't think it's a free, appropriate public education. And then we say, could, please attach a copy of this document to the last page of the IEP. And again, if that's all in writing, they're not going to be able to avoid dealing with that document. So does that make sense?
It does. What's the end game for that document? So if you've agreed to implement the IEP as written, but you have said that you don't think it's an offer of free, appropriate public education, what happens then?
Well, you're kind of laying the groundwork, I think, for later if you are going to do process. I actually was thinking this morning while I was getting ready for the program about how I want to do this case study in the next couple of weeks, starting with this family's first contact with the district where they tried to get him made eligible, and instead he was made, he was given a 504 plan. So I've been working on this family's due process all week, and they've been at this since 2012. So in September of 2016, there was an IEP meeting where a lot of stuff happened that I thought was wrong. And it was interesting to me because I went back and I looked at my IEP response, and it kind of reminded me of what my objections were, and it was helpful. So, I think that the end game maybe for us is different because, we want to be able to go back and say, look, we pointed out to you in September 2016 that the placement was inappropriate. Here's what we said. So reimbursement for the placement is proper because you've known about this in September.
Okay, so it doesn't necessarily mean that for that IEP that you're going to due process, but you're because see, I love this. There was a time when there was assessment done for my son that I was fine with the services. So I didn't like the assessment, but I didn't do anything about it. If I had realized that I could have said, I disagree with this and had it in his record, that would have made me happy.
Right. So that's sort of the idea is you're not sure whether you're going to object in the future, but if you do, we have a different burden. When we file for due process, we have to, convey the impression that we've done everything we could in a timely fashion to notify the district about our concerns, so they can't come back and say, well, if we'd known that you wanted this, we would have given it to you, so you're not entitled to fees for your workup on that particular issue. So, that's some of the reason, but also for us, students have multiple IEPs, and if you don't have to, if you aren't going to file for due process for a year, there might be 3 IEPs, and you will find it's easier to go back to them and remember what's happening if you've taken good notes and also, provided the district with a response.
Okay, great.
So anyway, that's.
But so again, for people who are just tuning in, if you're agreeing to the services, but there are other issues, you can put an asterisk after the parent's signature on the signature page and say, see attached letter. And then you can attach a letter that says what your issues are, and it becomes part of the legal document.
It does.